Hello and welcome to Delhi Law Firm. Today we are presenting a detailed legal analysis of a very important Supreme Court judgment that has become highly relevant across the country, especially concerning the Negotiable Instruments Act, specifically Section 138 and provisions relating to jurisdiction. This judgment is Jai Balaji Industries Ltd versus HEG Ltd, in which the Supreme Court has once again clearly interpreted the question of territorial jurisdiction in check bounce matters.
Certainly, this decision is extremely significant for all commercial establishments, companies, traders, and individuals who either file check bounce cases or have cases filed against them. Through this judgment, the Supreme Court has clarified how jurisdiction is to be determined after the 2015 amendment and how earlier judicial interpretations have now been modified in this area.
Let us first understand the background of this case from a legal standpoint. HEG Ltd, whose registered office is located in Bhopal, Madhya Pradesh, supplied certain goods to Jai Balaji Industries Ltd, a company based in Kolkata. In return, the accused company issued a cheque of approximately 20 lakh rupees. This cheque was drawn on a Kolkata bank branch but was deposited by HEG Ltd in their State Bank of India branch in Bhopal.
After the cheque was deposited, the very next day the bank returned it with the remark, "Funds insufficient." This triggered the statutory process under the Negotiable Instruments Act. HEG Ltd then sent a legal notice to the accused as required by law. Since no payment was made, HEG Ltd filed a complaint in a Kolkata magistrate court in 2014 because at that time, the prevailing law, Dashat Rathore judgment, linked jurisdiction to the location of the drawer's bank where cheque dishonour occurred.
This is where a significant change occurred. In 2015, Parliament amended the Negotiable Instruments Act, especially through the insertion of Section 142(2) and its explanation. The amendment made jurisdiction complainant-centric. Now, a complaint would be filed where the payee's bank account is maintained. Therefore, HEG Ltd withdrew the pending Kolkata complaint and filed a new complaint in Bhopal.
Subsequently, Jai Balaji Industries Ltd challenged this new Bhopal complaint, arguing that proceedings in Kolkata had already progressed substantially and therefore changing the complaint was not legally permissible. They also argued that the 2015 amendment should not apply retrospectively and that jurisdiction should still be determined by the place where the drawer's bank dishonored the cheque.
Ultimately, this dispute reached the Supreme Court. The Supreme Court had to decide two key issues. First, whether the 2015 amendment applied to this case and whether the Bhopal complaint was legally valid. Second, whether there was any legal basis to transfer the complaint back to Kolkata.
Let us now look at the legal position before the 2015 amendment. In 1999, the K. Bhaskaran judgment recognized 5 different acts as potential basis for jurisdiction: drawing the cheque, presenting it, dishonour, sending notice, and failure to pay within 15 days. Because of such wide jurisdiction, complainants would file complaints wherever convenient.
Then came the Herman Electronics decision in 2009, which clarified that merely sending notice does not create jurisdiction. What matters is the receipt of notice by the accused. After that, the landmark 2014 Dashat Rathore decision declared that the cheque bounce offence occurs only where the drawer's bank dishonours the cheque. As a result, complainants had to file cases in the accused city, causing significant practical difficulties.
To remove these complexities and hardships, Parliament enacted the Negotiable Instruments Amendment Act 2015. This amendment is detailed and precise. Under Section 142(2)(a), if the cheque is deposited for collection, the complaint must be filed where the payee's bank account is located. The explanation further clarifies that even if the cheque is deposited in a different branch, it will still be deemed to have been deposited at the payee's home branch.
The Supreme Court, interpreting this provision broadly, held that the amendment was enacted for the convenience of the complainant and to maintain uniformity across the country. Now, jurisdiction is determined on only one basis: the location of the payee's bank. The place of dishonour no longer determines jurisdiction. This interpretation aligns with commercial interests and judicial efficiency. The Supreme Court also held that the earlier Kolkata complaint had no relevance as it had already been withdrawn. The new complaint is independent and must be considered under the new law. Therefore, the argument that evidence had been recorded earlier was legally unsustainable. The court held that each complaint has its own independent existence.
Now let us discuss the final decision. The Supreme Court clearly held that only the Bhopal court had territorial jurisdiction. This jurisdiction is determined under the new section 142(2). Therefore, the court held there was no reason to transfer the complaint. The transfer petition was dismissed.
This decision has not only guided the case of HEG versus Jai Balaji, but also become a precedent for the entire country. Now, for filing check bounce complaints, the complainant no longer needs to go outside the city where their bank is located. This saves time, effort, and resources across the justice system.
This clarity is extremely useful in commercial disputes. This amendment and the Supreme Court judgment based on it makes the justice delivery process more simple, accessible, and complainant-oriented. It is also important to note that the law was introduced keeping in mind modern banking practices where a check may be deposited at one branch but cleared elsewhere. The explanation addresses this technical reality.
In conclusion, the essence of this judgment is that the territorial jurisdiction in check bounce cases in India is now completely clear. The complaint will be filed where the payee's bank account is located, and that place will be treated as the home branch. This decision by the Supreme Court is a significant step towards commercial stability and judicial clarity.
If you also need assistance related to check bounce matters, civil disputes, criminal cases, High Court or Supreme Court matters, Delhi Law Firm is available for you throughout India. We handle various types of cases across the country with professional legal services. For more information or assistance, please visit www.delhilawfirm.news.
Thank you. Delhi Law Firm remains committed to providing reliable legal support for all your legal needs. In our next session, we will bring you detailed insights on another important legal topic.